Good afternoon, everyone. You're welcome back to Tswa Film Festival Day 2, and we're about to start our workshop for the day, which is titled Protecting Your Craft, Contracts, NDAs, and IP for Creatives. We have two legal luminaries, partners of Night and Valor attorneys. Our first resource person is Selzing Zingfa. Selzing is a partner of Night and Valor attorneys, where he provides broad spectrum legal expertise and across multiple areas of general law. He has a strong passion for entertainment law and ICT data law, and is particularly versed in data protection. Selzing is committed to helping creatives and innovators navigate the landscape with clarity and confidence. And our second resource person is Folmi, Yohanna. Folmi is also a partner of Night and Valor attorneys, and his practice as a lawyer encompasses the full scope of general law across various fields. He holds a special and active interest in intellectual property law, and he shares his knowledge as part-time IP law instructor. Please clap for our facilitators. And we'll be starting with Folmi. So let's clap for him as he comes up.
Thank you very much. Thank you for the introduction. So even though what we're presenting on is protecting your crafts, contracts, NDA and IP for creatives, so I would like to change the sequence of what we're presenting. I think protecting your crafts, IP, NDAs and contracts. Why am I changing it this way? For you to know what to protect. Before you go into contracts, you need to understand what you want to protect. Then after knowing what you want to protect, the next thing is, oh, I want to share this idea with somebody. So I need what? An NDA. After you share the idea with the person, and you guys are going ahead with the project or idea, then you sign your contracts. So I would like to rephrase the topic to be protecting your crafts, IP, NDA, and contracts for creatives. So you know your craft, that's the most important thing, and you know it can be protected. Then the next thing is your NDA, non-disclosure agreement, then your contracts, that's the agreement between you and whoever you want to enter your creatives. Your project or whatever you want to execute. So let's, I know you've heard the word intellectual property. Intellectual property is simply creation of the mind. It's common to hear people say, oh, my intellectual property. Oh, my intellectual property. Yes, it's your intellectual property. But the question I have for you this afternoon, is your intellectual property an intellectual property right? There's another question. It's one thing for you to say, oh, it's my intellectual property. Is your intellectual property now an intellectual property right? So it's another thing. So there are certain standards your intellectual property must meet before it can qualify to be protected and called intellectual property right. So intellectual property simply means the creation of the mind. Like creation of the mind, you think and you manifest it into the tangible property or tangible whatever things. Sometimes you think, then you create. So it's creation of the mind. It's intangible property. Then we have the intellectual property rights, which makes your intellectual property now a right that you can protect. Then we have the laws in place that are meant to protect that right. So when we talk about intellectual property, basically intellectual property is divided into two. We have the copyright, and before I go into the types of intellectual property, there's something I need to point out. Let's discuss types of intellectual property. When we talk about intellectual property, There are usually types of intellectual property. Some people say types of intellectual property, while others say type of intellectual property rights. So they are used interchangeably. Whereas from my definition, I said intellectual property, then intellectual property rights. For me, I prefer to say intellectual property rights, because that's when you know your intellectual property. The next question is, your intellectual property a right? Has it met that standard to become a right? Then next, what are the laws applicable to that your intellectual property? So what are the types of intellectual property now? Let's go. Types of intellectual property, I like to classify my types of intellectual property into 3. But the major types of intellectual property are copyright and industrial property. But there are some rights that you cannot categorize them into copyright into industrial property. So I love to refer to those rights as sui generis right. So these are like image right, like plant breeders right, like if you go to some countries, image right, in some places they call it publicity right, merchandise right. So these are rights that you cannot place. So you can, example of a merchandise right is when you go to some some people using photos of celebrities on their shirts. You know, that's their merchandise, that's their intellectual, that's their image. You're using it to exploit and make money. So in some jurisdictions, that is protected. Maybe not under copyright or industrial property, but you can come under tort to protect such rights. So I like to refer to those type of rights. Image right, merchandise right, plant breeders right, all these ones, I like to refer to them as sui generis rights. They are on their own. But for the purpose of why we are here for creatives, we are here for actors, producers, and the rest. Our focus will be copyright, because industrial property has to do with industries. That's why it's called industrial property. That's where we have our trademark, our patent, our industrial designs, even though there are times that they are you can interchange them. For instance now, even though we are talking about copyright, you need trademark. Tswa, you can trademark it. I don't know whether it has been trademarked. Yeah, so you see, we are talking about copyright, but yet we are still saying, okay, go and trademark, even though it's an aspect of industrial property. So, and in the case of industrial design, you must create an art before you manufacture it into multiple dresses. For instance, the Ankara my friend is wearing there, it was an art. It was drawn before it went into production. So once an art, if an art is, you are making that art for the purpose of multiple production, then it's no longer protected by copyright. Then it's going to be under industrial design, because you intend to go into multiple productions. That's why toys and the rest cannot be regarded as artistic creation that can be protected under copyright. So I just needed to clarify. But while we are here for copyright. And when we talk about rights, copyright is a right that is a negative right. Why are we saying, you are saying copy, and you are saying is a right, and you are saying, oh, this person should not copy my work, is infringing on my copyright. So it's a right, yet a negative right. It's preventing people from exploiting your work without your consent. Without your consent. So people will be exploiting your work without your consent. So before I discuss further into copyright, what are the nature of intellectual property rights? These copyrights, this industrial property, what are their nature? So one of the nature of this intellectual property right is, one, they are territorial in nature. When I say they are territorial in nature, is that because your copyright is protected in Nigeria, doesn't mean it's protected in Ghana. So you have to go to Ghana and protect your copyright. But there is international collaboration. So we have treaties. So there is this treaty that we call the Berne Convention. So for countries that are signatory to Berne Convention, so if your work is protected in Nigeria, meets all the criteria for copyright, then it will be protected in Ghana, because Ghana is signatory to the Berne Convention. And Berne Convention is meant to protect literary, artistic, and visual works. The Berne Convention. Then we have the Roman Convention, which is for performance, broadcasting, and the rest. So this is territorial in nature, but once countries sign to those treaties, then if Nigeria is signatory to that treaty and it has domesticated the treaty, that means it's part of Nigeria's law. You can refer to something and say, oh, now it's part of Nigeria's law. Then that means Nigeria is, no, sorry, I'm confusing something. Okay, once Nigeria is signatory to that treaty, that, okay, we are signatory. So once your work is protected in Nigeria and Ghana is part of that signatory of that treaty, then that work is protected. But no, the first rule is copyright is territorial in nature, or intellectual property rights are territorial in nature. Another characteristics of intellectual property rights is the fact that they are choices in action. When I say they are choices in action, is that the right does not accrue automatically. When it is infringed, you have to go to court and enforce it. So that's why I said they are choices in action. So you can't just say, oh, my intellectual property has been infringed. Oh, my intellectual, without you taking the appropriate step to enforce it. So you need to go to court. That's why they said they are choices in action. Then another thing is that you can assign them. They are also, the fact that they are intangible property, they also have the characteristics of a tangible property. So you can assign them, you can license them, etc. So why intellectual property in the first place? One is to encourage innovation, and two is to allow people access to those work. Because if you innovate or you create and people don't use it, it's of no use. To protect your economic right as the creative or the manufacturer or the innovator, so that you will be encouraged to produce more or to come up with more creative stuffs. Then, and for the public to have access to it, there must be a balance. Public having access to the work and at the same time you enjoying the fruits of your labor. So having said that, let's move to copyright now. We are going to deal with copyright because that's where our concern is. We are dealing with film, we are dealing with music, we are dealing with, so that's where our concern is. So as I said earlier, copyright is a negative right. You said copyright is a negative right. You are talking copyright and you are saying, oh, don't infringe on my copyright. So that means it's a right that you cannot exploit economically without the person's consent. So you have to get the person's consent before you exploit such rights. That's copyright. Then what are those categories of work that are protected for copyright? And for context, since we're in Nigeria, our reference law will be the Nigerian Copyright Act 2022. The Nigerian Copyright Act 2022 for context. So everything we are going to say, we are going to do here is going to be limited to Nigeria. And we are going to refer to the Nigerian Copyright Act. So when we talk the categories of work protected by the Copyright Act 2022, so if you go to section 2 of the Act, Section 2 of the Act, the Act lists categories of work that are protected by copyright. And what are they? What are those works? These are literary, musical, artistic, audiovisual, sound recording, and broadcasting. These are the 6 categories of work that are protected by copyright in Nigeria. However, the copyright is not in some, okay, in Nigeria we have only the Copyright Act, but it does not protect only copyright. There is what we call performance right, and there is what we call folklore expression. They are all protected under the Act. I'm going somewhere, so you will know, I'm performing today, I'm performing, that's not copyright, that's performance right. So in Nigeria is what we refer to as neighboring rights. So why are they not referred to as copyright? Let me take you to why they are not referred to as copyright. For a work to qualify as copyright, there must be to qualify under Section 2. To be protected by Copyright Act under Section 2, there must be two things. One is originality, and the second one is fixation. So when we are talking about originality, you must have expense, effort in making it original. You are not just copying. It must be your original work. Then secondly, it must be fixed on a medium. You must fix it on a medium. That means it's not just enough for you to sing. If you come and perform here, that's a performance. It's not fixed on a medium. I cannot access it on a CD or platform, so it's not fixed. So that cannot qualify as a copyright. So for it to qualify as copyright, there must be fixation, and there must be it must be originality and fixation for it to qualify for protection under Section 2. That is your musical, literary, artistic, and sound, whatever. So that is where performance right and folklore expression comes in. You know, I said for it to be copyright, it must be original and it must be fixed. It must be original and it must be fixed. So what if someone performs here? The performance is original, but it's not fixed. So that is where the art comes in with performance right. So that one is also protected. Then what of folklore expression, our traditions and customs? You know, there are songs, there are musics, these ones, they are not written. They are also passed through oral communication. So the Act 2 also protects folklore expression through the Copyright Act, but they will not be protected under those categories of work, that is musical, whatever, because they've not met that criteria of originality and fixation. So that is it. So sometimes there is need to differentiate, okay, in some jurisdictions like South Africa, they have the Copyright Act, they have the Performance Act. They're separate. So if you are only doing performances, and in some jurisdiction, sound recording, some jurisdiction broadcasting is not part of copyright, it's under performance in some jurisdiction. In some because of my reading, I see some sound recordings too. They're under Performance Act. But in jurisdictions like South Africa, they have their Copyright Act, they have their Performance Act. So you can, it's not like Nigeria that if you carry the Copyright Act, you think, oh, everything is there, it's copyright. But it's not. For copyright, it's musical, artistic, literary, and audiovisual, sound recording, and broadcasting. There are 16 number. So there must be what? There must be originality and there must be fixation. So there's an important thing I want you to know. Ideas are not protected by copyright. The fact that you have an idea and it's not fixed is not protected by copyright. So if you say, oh, I have an idea and it's within the creative, I want to discuss it. Oh, I want you guys to sign a non-disclosure agreement. It's an idea. So if I were on the side of those people that you say, oh, sign non-disclosure, I'll say, you people should encourage the person to come. Since it's an idea. Section 2 sub 3 of the Act is clear. Ideas, methods, etc. are not protected by copyright. So if you say you want to sign an NDA, I will advise you to have it fixed in a medium or something before you go ahead and say, okay, I want to discuss with you.
What kind of medium?
Maybe Dix. If it is literary, you have it written, the manuscript, music, maybe on your phone or CD, you get it. That's why I said ideas are not protected. When it's fixed on a medium, that's why I said one of the criteria for copyright is originality and what? Fixation.
So, for ideas to be fixed on a medium,
If you just have an idea, oh, I have an idea of this play, you've not written it down, is not protected.
Well, it's written.
It's written, manuscript, written, like you want to go into production, do it that way. Then before you approach them, oh, I have this manuscript written for this play, or for this song, then you know songs are lyrics, so you write them down. You get it? So that originality and fixation must be there. But I said there is another aspect, which is the performance. So, because I'm working with time, and there's a second aspect. So let me quickly rush. Then there's, when we're talking about ownership, the issue of ownership. Ownership, when it comes to copyright, vexes in the author. General rule, that's the general rule. It vexes in the author, that's the general. The person who authors the work is the owner. That's the general rule. Section 28 of the Act. That's the general. But there are exceptions to those general rules. And to the general rule, you can also, let's say, the general rule says the creation vexes in the author, but you can have an agreement, you and whoever it is. Because there are times that you hire somebody to do something for you. There are times you hire somebody to do something for you. So you can decide to enter into an agreement. Oh, this thing that you're doing, the intellectual property is mine. I'm going to pay it off. You don't have anything. But the general rule is the authorship, ownership versus in the creator, unless otherwise agreed. Then if we go down, there are exceptions. When you are a government employee and what you produce is in the course of your employment, it belongs to the government. That's an exception. Once you are under an employment and what you are producing is for the employment, it belongs to the employment. You cannot claim that, except it's something not related to your work and you decide to create it, then that is where you can raise, oh, I'm the owner. But once it's in line with your work, then there are times that we do contract of service. Okay, contract for service. Sometimes we hire people, we commission people to do certain things for us. So in that case, that one too, you pay them for this thing and say, okay, oh, I want, this is my copyright, depending on the kind of how would I put it? Depending on the kind of contract, there are certain contracts that they know that, oh, the intellectual property must just be mine. But to save yourself from all kind of whatever, the ones that the act is not expressly stated in the act, that it belongs to you, just enter into an agreement. Just enter into an agreement with the person that, see, you are doing this thing, the intellectual property right belongs to me. You guys will sign agreement and whatever and sign. You will sign the agreement that it belongs to you. You are the owner, you that commissioned him to do the work. Those ones that are not expressed, just to avoid stories that touch eventually. Maybe in future now the work gains popularity, you come up and say, oh, I have so percentage. So it's very important. When the ones that are not expressly stated in the act, just enter into agreement. Or you are not sure, or you doubt whatever, just enter into an agreement with the person, stating that the intellectual property rights belongs to you. So if we check before I even go to ownership, I forgot to mention why copyright. So copyright exists for two reasons: to protect the moral right and economic right of the author of the work. Moral right to be accredited as the author. I'm the author of so economic right, that is the money that is to accrue as a result of that work. That is why we have copyright. So let me, on this ownership thing, photographs, drawings, all of these ones, all initial ownership belongs to the person who draws, to the photographer, to the whatever, whatever. But if you go down in section 28 of the Act, because we're talking Nigeria, so we're talking about the Copyright Act of Nigeria. If you go down, once you commission a photographer for an event, and you paid him for an event, for commercial purpose, event is for commercial purpose. In that sense, the photographer cannot come and say, oh, he owns that rights to authorship of that picture. Once for like an event that is, he cannot. But once you commission him for a private use, the pictures for a private use, he has a non-exclusive right to those pictures. You have a right to use the picture, he has a right to use the picture. However, you have another right. If you are not comfortable, you can restrain him from sharing those pictures with the public. Even though he has the right, you have the right to restrain him for private use. Once those pictures are for private use, you can restrain him. So the Act goes further in, if you check section 129, to define who authors are. Issues of who is the author of a work comes up a lot in this space. You hear there's case, oh, I'm the owner of this work, I'm the owner. So the Act in section 108 of the Act defines who are authors. So when we are talking of authors, when it comes to literary, musical, artistic works, the person who created the work, general rule, the person who created the work is regarded as the author. But unless otherwise decided. So if you are going anywhere, make sure you have music production. They said the person who are coming to sound recording. Then when it comes to audio-visual, that is films, audio and visual, your videos and all these are what we call audio-visual. So the person whom the arrangement for making of the work were made, the person who does the arrangement and everything, according to the Act, is the author. So if you leave it open, you go ahead and do audio-visual without signing the necessary thing, and somebody advises, this film is popular now. What role did you even play? Oh, I was the one who did the arrangement and whatever. Oh, was there any agreement signed or something? I don't know. Okay, let's go to court. And say, oh, since the Act says the person who arranges or whatever is the whatever. But there are other circumstances that the court will consider at arriving at decision, not just be whether and the rest. These are things of law and the rest. Then what the Act is the person who makes the arrangement, which in the case of audiovisual is typically the producer that does most of these things. So unless otherwise agreed, then issue of sound recording, the person who makes the arrangement of the arrangement. When we say sound recording, that is the composition of the beats, the sound, there are people that write the lyrics. The person who sing it, the performer or the musician. Sometimes it's the musician that will write at the same time perform the music. Sometimes he will just go and sing out the melody and whatever. So sound recording, that is the beats. The law says the person, the arrangement, the person who makes the arrangement for the making of the sound recording is the owner unless otherwise agreed. The person who makes arrangement. Because recently I was going through Facebook, I saw one particular, is it Instagram, one particular producer, all he does is to produce different beats. So I guess it's left for you to come and buy. So in this case, if you want to buy it from him, you have to enter an agreement and he's assigning the intellectual property rights for that sound to you, so that in future there won't be any claim over the sound or whatever, the music or whatever in future. Then when it comes to broadcasting, the organization, the broadcasting is considered as the owner unless otherwise agreed. Then when it comes to photograph, which I spoke earlier, the Act says is the person who, the photographer is the owner unless otherwise, and those exceptions that apply in section 28 of the Act. Then when it comes to collective work, collective work, that there are works that are a combination of different, maybe poetry. You will see some people do a book consisting of different poems. So the person who does the arrangement, the editing, or what in the act is considered as the person who owns that work, unless otherwise agreed. So these are the sequence. So let me, even though my colleague will talk about contract, but there are aspects of, so before you go into contracts, most times some people want you to sign a non-disclosure agreement. That's the meaning of NDA, non-disclosure agreement. Okay, what I want to disclose to you, I don't expect you to disclose it to another person in case it doesn't work between us. It's my idea, you cannot disclose it to another person. So people go to the extent of signing non-circumvention agreement. Non-circumvention agreement, that means maybe before the contract, or you've discussed the idea with us, okay, the next thing we want to do is to sign a non-circumvention agreement. That means you will not go behind our back and execute the project with another person. So you have NDA, and so people will go non-circumvention agreement. Maybe they've reached an agreement that, oh, maybe you are the owner of the work, then you approach me, then we agree that yes, we like your project and we are going to work with you. So because we are scared that, oh, you might go and meet another person, then we will sign a non-circumvention agreement. So NDA mostly is to protect the person who is disclosing, but non-circumvention agreement is also to prevent you that is the recipient of the information that you want to execute, so you can also sign that one. So that's why I said NDAs, I mentioned initially, ideas when it comes to copyright, don't go and table idea and say, oh, they've signed NDA. When it comes to copyright, no, don't do that. Don't do that. So, so that is it about copyright. So since, let me just focus on two categories of work protected under copyright. That is music, and let me just focus on music and let's see what are the agreements or what are expected of you as a musician if you want to, or film producer. Let's just focus on audiovisual. When I'm in this context, let's limit audiovisual to movies, commercial movies, home movies, and then music. What are those agreements you're expected to have as a musician or producer or whatever? You know, if someone is producing a music, there are times you have like 10 people that contributed to the making of that music. You who wrote it cannot claim that, except you are the producer, you are the sound, the person who mixed the sound, the person who does everything. Then you can now sit down and claim, oh, you are the owner. But most times we have producers, there are sound engineers. You have to go to the studio. So one of the things you consider drafting is a production agreement. Production agreement. You and the producer, okay, are you giving me a percentage, or you want to pay him off for his production? What is his price? Or are you giving him a percentage? That's production agreement. Then the issue of, there is another one that you need to consider, which is the split sheet agreement. Split sheet is the number of people that are contributing to that music. What are the percentages that is going to each person? This is an agreement as a musician, as whatever you should know you have. Even if the person came and just shout in the track, write the person's name down and say, oh, this person is entitled to 1% for shouting in the track. Because once the track is popular, they say, I was the person who shouted. So nobody, my right is there. I was not recognized. My economic and moral right, that right of authorship, okay, I'm the person who did that sound, that whatever. So you have your split sheet agreement. Another agreement is your publishing agreement. Publishing agreement covers the lyrics and melody. The lyrics and melody, this is usually assigned to labels and the rest. You will have it if you belong to the record label and the rest. The lyrics, then you need your distribution agreement. Distribution is after the entire song, like streaming. You want to give it to Spotify, Apple Music, people you want to distribute to. So these are some of the things. Because for detailed explanation, you need to consult an entertainment lawyer or a lawyer who is versed in music and the rest. Then there is another aspect that is very key in other climes. In Nigeria, we've neglected that aspect, and which are the roles of collective management organizations. They play a very key role in other countries. What do these organizations do? You know, as a musician, you cannot go all over Nigeria, or a film producer, to know where your music is being played and whatever to collect royalties. So what this collective management organization usually do, you assign the rights to them, or you license your rights to them, non-exclusive license. Some give them exclusive. Exclusive, that means you are excluding all other persons from using that work except that collective management organization. So in Nigeria, our ecosystem for collective management organization is not that huge. So we are still coming up. My thesis for my PhD, I'm writing on collective management organization, because it's an area I saw in other climes. People are making it big in that area. So my colleague will come and speak more on contract. Thank you very much.
Good afternoon, everyone. Yes, my name is Selzing, Zingfa, partner with Knight and Valor Attorneys, as earlier introduced. Well, basically, I'll be talking NDAs, that's non-disclosure agreement, and contract itself generally. So, well, first of all, I'll start by saying that I have this popular saying that I say our daily activities as humans is transactional. It is contractual, and in itself, we live in a quid pro quo world. Quid pro quo means you scratch my back, I scratch your back. If you look at it from the angle of life itself, from birth and even when we get to adulthood, it's been more of a transactional thing. And even today, each and every one of us here had transacted with someone before we got here. There's always an offer and there's always an acceptance when it comes to our daily activities. Oh, you want to buy this, you feel you're interested in this, or okay, as a film producer, you will need a director, and you offer to call, oh, director, I want you to work with me. You've made that offer to him, and in the sense that you say, okay, what is it in for me? That's an acceptance. Basically, there's a transaction between the both of you. And then it now leads you to, okay, fine, we have this agreement, let's put it down in writing. You form the contract there, right? That's it. So, well, talking about a non-disclosure agreement, I say non-disclosure agreement are basically, they are needed to protect that which is seen or perceived to be a trade secret. Either in the music industry, maybe an artist, oh, I wrote this and I want to protect this. And whoever he will be working with will say, okay, this secret is yours, okay, yes, it has to be protected for this given period of time. So, well, there is no limit as to having a non-disclosure agreement. A non-disclosure agreement can be entered between those in the film industry, the music industries, science and tech, and whatever we're doing. Basically, it's you trying to protect some sort of information that you feel should not be out there. That if you should get, it's an idea, or it's a trade secret, that if you should get into the wrong hands, you either your morality or you either suffer morally or economically. In the sense that someone gets to use it and they probably use it in the bad light, you suffer that morally, or they now they give it a bad name. And then if you're talking about the economic aspect of it, Someone can just duplicate your work and then make profit off it. Just like my colleague mentioned on you protecting your intellectual property rights. So these NDAs, basically it's very important in all our transactions that we do daily, and as far as entering a contract with someone, but it's basically important, and I've narrowed the importance of it into 6. One is for the protection of confidential information. Now, there's this information, I've learned how to make banana bread, right? So I will try as much as possible. I have this special way of making banana bread that I put up on the toppings of it will be nuts and other things I wish to have there. But I so doing, you say, okay, please, I'm going to be working with this other baker or this person that will be my mixer and the rest. Like, okay, this and this are what I'm adding to it. So, however, I don't want this secret of mine to go out. So please come, let's sign a non-disclosure agreement of that information, which you're going to be privy to while we work on the project or while we work in the same office. So basically the protection of confidential information. Then 2, that builds trust. It builds trust between parties. You'll be very much comfortable to want to work with me if you believe that your trade secret will be protected, right? I'll say, okay, if you know that you have this assurance that definitely, if I'm transacting with Tswa Film Festival, or Tswa Film basically to produce this movie, if I get to disclose certain information, it will not be out there in public. Because they've agreed that we're going to reduce it into writing, and that will be a non-disclosure agreement. So it basically builds trust between parties and also helps in making deals. Of course, if I'm comfortable to make deal with you, to seal up a transaction with you today, knowing that my trade secret is protected, I want to come back to you again and again to come to seal deals. Then thirdly, it prevents theft of ideas and trade secrets. What my colleague Folmi talked about, basically IP. So if you're having, you've agreed and you've identified that these are my intellectual property that I want to protect, the next thing that comes to mind is, okay, I need to sign a non-disclosure agreement with people that I'll be coming across with in the course of a particular transaction or trying to see a work from start to finish. Number 4 is that it clearly defines what information is confidential and then the duration of that contract. Now, some things that might come off to you as confidential might not be confidential to the other person. So having a non-disclosure agreement basically helps you to understand, to say, okay, to help the other person rather to understand that, this is what this person sees as confidential to him, as a trade secret that he wants to protect. So that it is clearly defined. You know that, okay, XYZ are my trade secrets and I want to protect it. So please, let's have that agreement. And then you now talk about the duration. On duration, basically you could say, okay, I want this trade secret of mine to be protected for a given period of time. To say, for maybe 2-3 years, this is what has happened between the both of us. Let's protect this for now. I don't want this information going out to the public yet. But after 3 years, you can disclose whatever you wish you want to disclose. Let me give an illustration now. I don't know, yeah. We've had it one time too many. I think I googled it one time to check that John Bellion had wrote some songs for Yohanna, and she had performed those songs. Yes, so that was done. She performed the song. It was recorded. So I think Monster is the name of that song. So not until after she had released the song, it made waves, it was liked, and then probably after 2-3 years, we heard that, it was John Bellion that co-wrote that's song for her. But throughout that period, most likely, my opinion, I think they had a non-disclosure agreement within them that lasted for that period, and they said, okay, I did this, but please keep this information on the low for now until after this certain duration, you can as well go out to disclose. Yes, then yes, it reduces the risk of disputes and litigation. Basically, if we've entered an agreement, the contract, that is the NDA, non-disclosure agreement between two parties, and I'll say, okay, please, this and this are the information that I don't want going out. But if you on your own part now, the other party, decide to not disclose, to let out that information, of course I'll be aggrieved by that act of yours. And I will definitely want to, if I feel I've suffered some sort of economic loss as to your own act, I would want to sue you for breaching our contract, for disclosing information that ordinarily ought not to be out there. So basically, if you have that non-disclosure agreement, it tells the person, before the person might not say, oh, I did not know that this is a trade secret to you. So I did not know that, oh, you did not want this information out, but I just disclosed, I talked about it unknowingly. But if you have it defined, it is clear, right? Clearly stated, it protects, it reduces the risk of having any dispute between two parties. Yes, before you now say, oh, I want to go institute a lawsuit against that person. And then a non-disclosure agreement also helps to ensure the compliance with data protection and privacy laws. In Nigeria here, we have the Nigerian Data Protection Act that made provision for the Nigerian Data Protection Commission. It's a body, a statutory body that regulates and protects, regulates basically the protection of our data as humans. So, ordinarily that is what, I've done a non-disclosure agreement between, we've signed on a disclosure agreement with this person, and I'm trying to protect certain things, right? So, if you have that non-disclosure, it also helps with the compliance itself. You can say, okay, please, X, Y, Z about me or about this project should not be disclosed. So you're protecting the data, the right of that person. And then when it comes to now talk about compliance, like you're trying to, there are certain information of you that should not be out there, which is to be protected by the Nigerian Data Protection Commission. It helps you to be compliant, to meet up the whatever requirement it means to protect the right of that person. Yes. Okay. Yes. Earlier, my colleague talked about NDAs and having a non-circumvention agreement as well. Well, so basically, like we made it known from the beginning that yes, the non-disclosure agreement, the contract that's entered between two or more persons. Yes, and then you are trying to basically protect an idea, right, or a trade secret, or whatever it is, from it to be readily available for the public to either explore the moral or the economic benefits that you hold. So, but basically, in practice, you could actually have a non-disclosure agreement and have a clause in it that is for the non-circumvention. Yeah, so you have this idea, you're saying, okay, this is my idea, this is my work, or this is my trade secret that I don't want out there to be accessible by anybody. And simply because I am coming to I'm transacting with you on this or working with you on this project, and you happen to know that secret of mine, that idea of mine, how I came about a particular thing from start to the point where you come to join me, right? You're trying to protect that. And then you have that. And then on the other hand now, sometimes maybe it could be, oh, you're an artist, oh, okay, I've produced this song, okay, I've written this song, I want to record it, and then I want you to be my producer, like that. Before you enter, yeah, so you sign a non-disclosure agreement, or there's certain information that you've learned over this transaction with this person and you don't want it out there. Then on the other hand, you now say, okay, I know this good marketer that we can help, or a digital marketer, or yes, that we can help promote this song and then collect what is ours, like the royalties. And then you will now be like, okay, fine, I want to connect you with this person, but we need to sign a non-circumvention agreement, in the sense that if I connect you with this person, we've met, you don't go behind my back to meet up with that person to now probably continue that transaction on that song, but you have to go through me, I have to be involved. So basically the essence of me explaining this is the fact that you could actually have a non-circumvention clause included in the non-disclosure agreement. And then lastly, we'll be talking about, just to give a little explanation, yes, as to what contract is. A non-disclosure agreement itself, it's a contract that is entered between any transaction that you enter between yourself and another person. It's a contract, and it can either be implied or it can be expressed. Expressly stated in the sense that, oh, we break this down. I want you to do this for me, XYZ thing for me, and then you're like, okay, if I do XYZ for you, you're going to pay me XZ amount, and we agree on that. That is a contract that has been expressly stated and entered between the two of us, and that can be either oral or in writing. It could be reduced into writing. So it must not necessarily, they mustn't necessarily say that, oh, every contract has to be written like that. But however, written contracts carries weight, because something has been reduced into writing. No, it gets to tell that, okay, yes, you are aware of this. It's not that it was doctored or something, but if it is just word of mouth, oh, denial comes in. You say, oh, I agreed with you that you're going to produce this movie for me for 50,000 naira. Or we agreed that you're going to produce this song for me for 1,500 naira, and you don't have any right, intellectual right, when it comes to collection of royalties from the song or from that work. So, but if you have this, you stated that, okay, this is it. This is the contract that exists between the both of us. It has been written down, right? The paper, I have my copy, you have your copy, a counterpart copy. And whenever there's an issue, I come with it and say, okay, this is my old copy of the contract. This is it. I did not doctor this, I did not make this on my own. It's not that I'm saying what I don't know. This is it. So it speaks for, it helps out, and then it gives you legal backing to that. And then when you're talking about implied, when the contract is seen to be implied, is say from the aspect that, oh, I expect you to do this. It is not expressly stated, but it means that I expect you to do this. I come to you and say, okay, this is my house, let's enter a contract, it could be oral, like, okay, roof this house for me. I expect you that, okay, I said, oh, roof this house for me, and in this day and time, of course, we should be roofing this house with a lentil aluminium, or probably glass or marble or whatever. Not with grass or, yes, things like that. So it is implied that, okay, this is what I want you to do in this contract, and I'm going to pay you good money, or I'm going to pay you for that service which you render. Yes. So basically, these are some of the things that we need to know as artists, either as music artists, yes, songwriters, performers, movie producers, actors, and the rest, that you should always have a contract handy with whoever, the second person that you're dealing with. You should always have a contract entered with that person. Yes. Thank you.